All rise. We will there. Please be seated. We was a swap.
Thank you very much. And witness, welcome back. It's time back. We're in public session.
Thank you, Your Honor. We can continue so for a few minutes. Mr. Witness, welcome back. You were asked various questions by my learned friend from Mr. Ruto relating to the composition of the Board of Governors of Location D. Do you recall that?
Yes.
Can you help the court, please, Mr. Witness? Is it a legal requirement in Kenya for a school to have a Board of Governors?
Yes.
And is it correct then that at all times there should be persons available to fulfill that function?
Yes.
We've noticed from documents that were shown to you by my learned friends, and I don't think we need to call it up. I'll refer to them for the record. It's Ken D09 0038 0080, Ken D09 0038 0426, and 0038 0427, and finally 0038 0429. They're at tabs 11, 15, 16, and 17, respectively, of the Ruto Defense Second Bundle. Mr. Witness, you recall that those documents established that the Board of Governors of Location D had expired already in 2007. In fact, from the first document at tab 11, it appears it expired already in July 2007. You accept that?
Yes.
And at tab 16, we see that the board, despite the fact that their term had expired, the Board of Governors met again on the 21st of September. You recall that?
Yes.
And the last document that was shown to you is at tab 20. It's Ken D09 0038 0435, which purports to appoint a new Board of Governors, including the two persons whom you mentioned in your statement. You recall that?
Yes.
And according to this document, the term ostensibly began on the 1st of April 2008. Correct?
Correct.
So in the documentation, we have a gap between September 2007 and September 2008, where we don't know who the individuals are from the documentation who were acting as the Board of Governors. Is that correct?
It is April, not
Mr.
September.
President, that is definitely not our understanding of the record, and I do not think that my learned friend is getting things correctly. Perhaps he should put the documents to the witness, and then the witness answers the question. But certainly we don't think that is correct.
Firstly, if I can correct, when I misspoke, I meant between September 2007 and April 2008. Your Honours, the documents speak for themselves.
That's really what I was thinking. And what I said to Mr. Fowl, who wanted to object to some of your questions, also applies to you. Yes. Counsel should be discerning in knowing what is more appropriate to do in submissions at the end of the day versus keeping a witness on the stand and dragging him through every argument counsel may see fit to make in a case.
Your Honours, duly noted, the purpose of approaching this with a witness was to firstly establish that there must have been a Board of Governors, And secondly, to establish that he had no further knowledge other than what is contained in these documents. And I think we can then move on. I'd like to move then to your questions that were asked to you by my learned friend for Mr. Ruto regarding the women and youth meetings that are contained in your diary and described in your second statement to the prosecution, that is Ken OTP 0109 0071 at 0076. Your Honours, I understand this is indeed at tab 21 of the prosecution binder. Can you confirm that, please? Yes. Mr. Witness, at paragraph 30 of that statement, well, let's start with paragraph 32. You mentioned that the women's event at Mr. Ruto's house was a yearly event. Is that right?
Yes.
So it wasn't just something which happened in election years, correct?
Yes.
And what was the purpose of those annual meetings?
No, I believe it was just because of happiness. Then people meet and talk.
And did it have anything to do with the time of year at which you say this took place, on the 26th of December?
It didn't have a specific time of the year.
I see. Let me then take you to paragraph 30, and I'll read it out to you. This is to do with the youth rally. You say the rally for the youth at Ruto's home is a yearly event where Ruto gives out money for Christmas. Is that right? Is that what you told the investigators firstly?
Yes.
Is that correct? That this is a yearly event and it's to do with Christmas?
No.
What is wrong about that?
What is wrong is that the youth meetings were, it is not yearly. It is once in a while.
So let me understand you correctly. The women's meetings are yearly, but you say the youth meetings, I'll rephrase. In your statement, when you say the women's meeting was a yearly event, that's correct. You confirm that?
Yes, at that time, yes.
And in the same statement, when you say the youth meeting was a yearly event, that was incorrect. Is that
Yes.
what you're saying?
Yes.
You see, I put to you, Mr. Witness, that in fact, what you told the investigators was correct. These were not political events, but these were events held yearly at about Christmas time. Isn't that right?
Mr. President,
Yes.
that's argumentative, and there's no basis for that assertion to be put to the witness.
I'll leave it at that, Your Honours. Now, you have spoken a lot, we're in public session, but you've spoken a lot about the lady and her circumstances and her involvement with the prosecution. Is that right? You know who I'm talking about?
Yes.
And Your Honours, may I go into private session for a few questions on this point?
Private session.
We're in open session, Mr. President.
Mr. Witness, my learned friends showed you a schedule of payments that you received whilst you were under the care of the prosecution. You recall that?
Yes.
And it was put to you that there were no payments made to you over the period of the 6th to the 8th of July, or no payments recorded over the period 6 to 8 July 2013, when you were interviewed by the prosecution in the location you have mentioned. You remember that?
Yes.
Can I ask the court officer to call up document KenOTP 01130296? Can you call up the redacted version of that, please?
Mr. Steinberg, the redacted version of document CAN OTP 01130296 is presented to the witness.
You see, is that your signature at the bottom of that document, sir?
Yes.
Now, is it correct that you were signing for receipt?
Mr. President, we unfortunately do not have that document displayed on our screens.
I beg your pardon, perhaps
Where
can
is
we
it- where is it on the
broadcast
tab?
that document? Your Honours, this is it's not in the prosecution bundle. I'll ask it to be broadcast. This is this is rebuttal evidence, Your Honours.
Mr. Steinberg, we cannot find the document under e-court. Could you please give us the ERN number of the first page?
Mr. President, may I also ask whether this material has been disclosed to the defense?
Your Honours, to answer my learned friend's question first, it was disclosed on the 13th of December last year. Madam,
The question I meant to ask is whether this material has been included in the prosecution list of materials for use in this examination with the witness.
Your Honours, I've answered that question. This is rebuttal material. It goes directly to what we submit is an inaccuracy and a misleading question put by my learned friend relating to the expenses over this period.
Mr. Steinberg, we'll leave it at that. That's the end of, let's stop the questioning now.
As the court pleases.
Yes, and that's the end of the examinations. That's what I meant.
Your Honours, there is one final issue, matter of housekeeping, and that is to assign a PIS number to the prosecution PIS.
Oh, yes.
The prosecution PIS related to witness KEN OTP P0604 will bear the number KEN PIS 00010073.
Thank you.
Mr. President, we make the same request for the Ruto Defense PIS. We do not propose to ask any questions of this witness. Thank you.
Thank you, Mr. Fowl.
With your permission, Mr. President, there is a transcript of an audio that we produced yesterday. The wrong transcript was put in. With your permission, we would like to make the correction on record. We have corresponded with the court officer, and they asked that we do the correction on record. With your permission.
Please proceed.
With your permission, Your Honor, I would request my case manager to read out the correct ERN number.
Your Honours, we apologise. We omitted the wrong transcript yesterday with reference to real-time transcript 136, page 116, lines 9 to 10, and page 118, lines 19 to 20. The audio that was admitted concerning the 25th of December 2007, Ken D11 0013 0028, admitted as EVD 48 for the same defence. We admitted as EVD 49 the wrong transcript. On the record, the transcript currently admitted as EVD 49 is Ken D11 0014 0209. However, we would request that EVD 49 instead be Ken D11 0014 0568, sir.
Where is the tab again?
That will be tab 12, sir. It's the transcript for the 25th of December 2007.
Prosecution, do you have any observation on that?
Your Honours, I'm informed that what my learned friend for the case manager says is correct. We have no objection.
So the correction is affected.
The document KEN D11 00140568 will bear the number EVD T D11 00049. And I take this opportunity to inform you that the PIS of the defense for Mr. Ruto related to witness KEN OTP P 0604 will bear the number KEN PIS 0001 0078.
Thank you very much. And Mr. Kiginkatwa, Mr. Fowl had indicated he had no wish for further question for this witness. Is that the same with you?
Yes, the same with us, Your Honor.
Thank you. And to the parties, is there any reason why the witness should not be discharged from his subpoena? Prosecutor?
None that I can think of, Your Honour.
Same here, Mr. President.
No, apart, Mr. President.
Thank you very much. Witness, thank you very much for staying part of the proceedings all these days with those questions from counsel. And we thank you very much for attending to answer the questions asked of you. We know it's difficult sitting, or as the case may be, having everyone asking you questions, including the judges as well, from time to time. Thank you for answering them. The chamber will assess your testimony alongside the other evidence in the case when the time comes. You are discharged from the stand as a witness, and also you are discharged from your subpoena. You've done your job. Mr. Mutai, thank you, Mr. Mutai, for again, on your part, sitting patiently and assisting the witness.
Thank you, Mr. President, and thanks to the court too.
Thank you. You will now be escorted from out of the room in the video link location.
Yes, Mr. President, I will escort Mr. Mutai and the witness out, and I will confirm when they're out of the room. Mr. President, the witness and Mr. Mutai have left the video link room.
Thank you. And is it the case that the next witness is on standby?
Yes, Mr. President, the next witness is on standby.
And I understand that the next witness has counsel. Is that the case?
Yes, Mr. President.
All right. The counsel may be brought into the room.
Okay, Mr. President. For logistical matters, I would just request that we have a few minutes for the next counsel to come in.
All right.
Thank you.
Your Honours, perhaps if I can just inquire while this is being taken care of, will it be possible to start with the next witness before the lunch and adjournment? If so, we just need to do some rearranging on this side.
No, we will not be starting with the next witness. What we propose to do to be to, once the council comes in, we attend to submissions and that may maybe engage in the proceedings.
Thank you, Your Honours.
Yes. Mr. Steinberg, there is a pending application, isn't there, for in-court protective measure?
Your Honours, my learned friend Mr. Garcia will speak to that.
All right.
Mr. President, the counsel of the next witness is present in the video link room.
Thank you very much. Welcome, sir. Could you please state your name for the record?
Thank you, sir. Mr. President, Your Honors, my name is James Jeroge Juguna.
Kindly spell it for the record.
James is James. Jeroge is NJOROGE. Juguna is NJUGUNA.
Thank you very much, Mr. Njuguna, and for joining us. The Chamber has been advised that you have been provisionally put on the list of counsel entitled to represent persons before the court. Is that the case?
That's the case, Mr. President.
In this matter, to represent or to appear in the interest of witness 495.
That is true, Mr. President.
We also understand that you've had an opportunity to review the any statements made by witness 495.
That is also true, Mr. President.
We will note that your role in this matter is purely to represent the interest of the witness where there is the possibility of self-incrimination engaged when a question has been asked of the witness. And it is not your job to participate in the substantive testimony of the witness on the main issue. Do you understand that?
I understand that, Mr. President.
Okay. You have the right from time to time when you feel that matters of self-incrimination have been engaged, you have the right to intervene at the appropriate juncture and inform the court of that. Do you understand?
I understand that, Mr. President.
Is it also the case that you have met with witness 495 and you've advised him of the provisions of Rule 74?
I have done so, Mr. President.
As you know, Rule 74, sub 3C, also refers to Articles 70 and 71 of the Rome Statute. Did you advise the witness of the provisions of those articles?
Yes, I've taken him through the articles, Mr. President.
Thank you. The Chamber notes that the prosecution has not originally identified any specific issues of self-incrimination likely to arise. Prosecutor, you would have the opportunity to discuss that, and it would be appropriate to do that in the presence of Mr. Njuguna, so he knows.
I can do that, Your Honours, although my learned friend Mr. Garcia will take the witness. The position is that from the information the witness has provided us there's no reason, the prosecution has no reason to believe that any of the answers he may give will incriminate him in any of the post-election violence. However, there are certain matters.
All right, wait, 1 minute. Maybe we should go into private session now.
All rise. We will obey. Please be seated. We'll use the swap.
Thank you very much. The chamber renders its rulings first on the matter of Rule 74, assurances for witness 495, and also on the matter of restrictions on contact for the duration of the witness's testimony. The chamber notes that an issue of self-incrimination may arise in the context of the anticipated testimony of witness 495. The chamber has heard from the prosecutor on this matter and the prosecution's undertaking. And the chamber now renders the ruling as follows. Where issues of self-incrimination arise, the chamber may, having consulted in particular with the prosecution, provide an assurance pursuant to Rule 74 of the Rules of Procedure and Evidence of the Court, in order to enable the witness to testify truthfully without fear of the consequences of self-incrimination. Such an assurance would, as specified in Rule 74 sub 3c, be with regard to maintaining the confidentiality of the witness's testimony and providing an assurance that the testimony would not be used directly or indirectly against the witness in any subsequent prosecution by the ICC. It is recalled that the court cannot provide any guarantee against prosecution in the domestic jurisdictions. However, in order to give effect to the assurances that the court may give, measures can be adopted, including the hearing of the testimony in camera, the protection of the identity of the witness, and the placing of relevant transcripts under seal. It is noted that an assurance under Rule 74 will not ordinarily cover any offense indicated or provided for in Article 70. In relation to Article 70, sub 1a and b, provided the witness tells the truth before the chamber and does not present false or forged evidence, the witness need not fear incurring liability under those provisions. Article 70 sub 1c of the statute relates to, amongst other things, corruptly influencing a witness. In this instance, the chamber notes that the prosecution has undertaken that any evidence provided by the witness before the chamber in this case will not be used against him for purposes of subsequent prosecution under Article 71c. Accordingly, the chamber rules that information provided by the witness during his testimony before this chamber may not be used in any subsequent prosecution against him pursuant to Article 70 sub 1c. In hereby granting the Rule 74 3c assurances to this witness, on the understandings and with the modifications just outlined, the Chamber has been mindful of the factors specified in Rule 74, sub 5. In order to give effect to the assurance, the Chamber orders that for any part of the testimony of this witness where issues of self-incrimination arise, the following measures will apply. 1. The evidence shall be given in camera, that is, in private or closed session. 2. The identity of the witness and the content of such confidential testimony shall not be disclosed in any manner. 3. Each of the accused, counsel in the case, both prosecution and defense counsel, the parties, participants, and court staff present or otherwise with access to the evidence are hereby specifically cautioned that breach of this order may result in sanctions under Article 71 of the Rome Statute. 4. The relevant confidential transcripts of the evidence of this witness will be placed under seal. And 5. The court will apply appropriate protective measures to any subsequent decisions in order to give effect to this order. It will be primarily the responsibility of the parties to ensure that all questioning which may touch on aspects of the witness's evidence likely to give rise to issues of self-incrimination is conducted in private or closed session. The witness or counsel appearing on his behalf may, in the same manner, also request private or closed session if it is anticipated that any answer to any particular question may give rise to self-incriminatory testimony. Counsel assigned to the witness is directed to ensure that the witness is fully informed of and understands this ruling prior to the commencement of the witness's testimony, and for that purpose, the testimony of the witness would only start today after the luncheon break, which is at 2:30 our time. That gives counsel ample time to meet with the witness in order to apprise the witness of the ruling of the chamber. Finally, restrictions on contacts with witnesses during their testimony would apply in respect of witness 495, in particular, for the duration of his testimony. Counsel for the witness is only permitted contact with the witness on the conditions applicable to the legal representative of dual status witnesses. Accordingly, counsel should refrain from holding any substantive discussions with the witness about the topics that are to be dealt with during his evidence or the exhibits which may be produced. But counsel assigned to the witness may give him advice at any time in matters relating to Rule 74, that is, matters of self-incrimination. Moreover, the basic principles for contact with witnesses are set out in the witness preparation protocol, and they shall apply in respect of any contact, whether before or during his testimony, including any contact with counsel. These principles prohibit coaching, training, or practicing of testimony, as well as any attempt to influence a witness to testify to factual events that the witness did not observe or perceive. That concludes the ruling of the chamber on the matter of Rule 74. The next ruling concerns the in-court protective measures applied for by the prosecution. On the 28th of August 2014, the prosecution requested the usual menu of protection, that's image and voice distortion, use of pseudonyms and in-camera sessions and redactions to public records were necessary to prevent identification. On the 5th of September 2014, the VWU provided its observations supporting the prosecution's request. As requested by the Chamber, the defense for Mr. Ruto and Mr. Singh have registered their observations as well as the counsel for victims. Having considered the specific circumstances of this witness, as well as the observations provided by the VWU and the oral submissions of counsel, the Chamber considers that the requested protective measures are necessary and therefore grants them. In other words, the use of pseudonym for the duration of the trial, voice and image distortion, testimony to be given in private session for any identifying part of the witness's testimony, and should portions of the private session transcript be reclassified as public, redactions to be applied as necessary. And of course, part of the circumstances the Chamber took into account matters pertaining particularly to the Rule 74 assurances given earlier. That concludes the ruling of the Chamber on the matter of in-court protective measures. I note now that it is 10 minutes to 1. This will be an appropriate time for us to take our lunch break, and then we'll come back with the witness on the stand. Court rises.
All rise.